welcome back, everyone, to our second panel. Now, I would first of all like to congratulate on our conference organizers for such an excellent lineup of distinguished speakers, not only on this panel, but also on many other panels. Now, panel one has helped lay the conceptual and the methodological ground for very much the second panel, which is focusing on three very important jurisdictions in Asia, including Japan, mainland China, and Macau. So in this panel, we have four distinguished speakers. Our first speaker is Professor Megumi Hara. Now, Professor Hara is a professor at the law school of Gakushuin University, Tokyo, where she teaches civil law and trust law. She is also appointed by the Ministry of Justice as a researcher consultant on the project to reform the immovable property law and its registration. Professor Hara has published numerous articles in the field of property law, as well as other topics concerning civil law. So Professor Hara will be commenting on the position on Japanese law. Professor Hara, the floor is yours.
Hello to everyone, and I would also like to thank the organizers for inviting me. And I would also like to extend my biggest thanks to Professor Prof for his patience and Bonnie for helping to organize. And please bear with me to share the slides. Okay, so here I think I should be having my slides. Here we go. So today I would be talking about the role of the law of unjust enrichment in Japan. And this is going to be the content of today's topic. First, I would briefly like to talk about the structure and history of civil code in context, in relation with the unjust enrichment. And then I would like to move on and discuss about the two theories of unjust enrichment, which is very interesting because there is a big clash in Japan between the court and the academics, where court support the theory of equity, whereas the academics support the classificatory scheme of unjust enrichment. And then moving on, I would like to discuss about the reform, which is very timely, which came into effect just this April, which have created a new article on enrichment claim, which derives from void contract or void juristic act. And then at last, I would like to talk about the measurement of enrichment, which is a homework that was left from the reform. So this will be my content today. So first, if you take a look at the slide, you will see on the left-hand side, the general overview, the bone, the structure of our civil code. You can very well see that this follows the BGB, the German civil code, with just a minor change of a reverse in book 2 and 3, where we have the real rights in book 2 and the claims in book 3. Under the claim book, there is a chapter on unjust enrichment, which states the generalized rule on unjust enrichment, just as the German code does. So I would like to read the Article 703, which stipulates the generalized rule on unjust enrichment in Japanese civil code, which provides as follows. A person who has benefited, hereinafter referred to as recipient, from the property or labor of others without legal basis and has thereby caused loss to the other, shall assume an obligation to return that benefit to the extent the benefit exists. So you see the four conditions here: the benefit without legal basis, causation, and loss. And then the effect is, as you can see, that we also have this defense of de-enrichment. So this is the general rule of unjust enrichment in Japan. So here, very briefly, I'd like to talk about the history of Japanese civil code. First, we started off as following the French civil code, which Gustave Wasnad, who was a professor at Paris 1, came to Japan and he was appointed to create the civil code and the criminal law. He was the follower of natural law, so naturally he implemented or tried to implement a thinking of natural law to our system. So at first, this old civil code had a generalized article on unjust enrichment based on the natural law understanding of justice. But then this old civil code never came into an effect because of this debate of what we call the debate of code, which basically was a debate between the conservatives and the people who wanted to move forward with this code, and the conservatives won, which we use this slogan quite a lot: rise of the civil code would mean the fall of fidelity. It basically includes the family value as well, because if you take the Western value in the civil code, they were concerned that the family value of the then Japanese time might not be correctly influenced. So then they decided to create this new committee involving 3 very young academics of Tokyo University that were the main drafters of the civil code, which is still effective until today. The interesting fact is that these 3 scholars, who were influenced by French law, German law, and English law, were very critical in applying morality and justice to determining the enrichment claims. So they explicitly threw away that notion, discarded that notion, and they created so that the enrichment claim was admitted simply because there was no legal basis. So that was the start of our civil code. What is ironic was after this codification of our civil code, what happened was there was a very strong German influence after this, which we call the era of academic transplant as opposed to legal transplant, which arguably continued until 1950s, some places until 1920s. So there's a dispute, but still we have this very strong German influence where some people have joked saying that anything introduced in Germany half a year later would be introduced in Japan. So unjust enrichment, since we follow the German law very closely, was of course influenced in this era, but this influence continued on unchallenged after the 1950s because our code was so aligned in this aspect with the German code. So at first, before 1950s, the theory of equity was the dominant view in Japan because the scholars feel that there needs to be some generalized understanding, a unifying value that unifies the entire unjust enrichment rule, which they could only find in equity. So they would say the generalized rule of unjust enrichment could only be convincingly explained as a corrective to injustices. And this is the view still taken with the Supreme Court. And I will here on call this as the orthodox view because this used to be the dominant view before, but not so as much now. So we have the Supreme Court following this theory of equity, but then in 1950s, influenced by von Kemmler and other German professors, academics back then, the classificatory scheme was introduced in Japan. So this classificatory scheme basically means that different conditions and effect apply in an enrichment claim, reflecting different order, whether it's contractual or ownership, in the civil code. And this today is the dominant view in academic. So I will try to explain this classificatory scheme in a bit more detail, following Professor Kawamura's theory. So if you take a look at the right-hand side of the screen, you will see that I have put a picture of a relation in a society. Kawamura divided the society into 2 relations. One was contractual relation, and the other was private ownership. And he found that enrichment claims had to reflect these 2 social relations. And so for contractual relation, he found that the enrichment claim derived from a performance should be the category of enrichment. And the other was the private ownership aspect, which was seen in the claim of the enrichment claim based on unlawful interference. So he categorized the unjust enrichment into two types. He also categorized the remedies in civil code, dividing them into two remedies. One was fault-based, and the other one was non-fault-based, which is impersonal remedies. And he put unjust enrichment in that category. So this was Kawamura's scheme of understanding the classificatory unjust enrichment claim. So from here on, I would like to view a little bit about how the classificatory scheme criticizes toward the orthodox view. And I would focus on two aspects. One is, if you take the classificatory aspect of the scheme, you must try to make all the protective measures inside of that relationship aligned with each other. So if we take the example of the protective measures of contractual relationship, what had to be aligned was the rule on effective cancellation with the rule on enrichment claim derived from performance. So for the rule on effective cancellation under Article 545, there is a wording saying that the obligation to restore is the obligation to restore the other party to that other party's original position, which means that the liability extends to everything he has received, including fault of fruits and other benefits, regardless of innocence. So here we have this wider liability, but then if the enrichment claim of Article 703, the generalized rule, applies, it means on the top part of the slide, the innocent recipient who is without knowledge that he has unlawfully enriched have only to return the benefit to the extent the benefit exists. So you see that there is a difference between the effect. So it was criticized that these two measures had to be in line with each other. Another criticism toward orthodox view, which was taken after by the drafters of this recent reform, was this slide. So you see that, taking example for a sales of contract of bicycle, there is a seller, there is the buyer. Let's say that after the bicycle was received by the buyer, the contract became void due to mistake, due to fraud, something of those reasons. So if the contract becomes void, it means that, of course, the obligation to restore occurs. So for the seller, it would be the obligation to give back the money that he received. For the buyer, it would be the obligation to restore the bicycle. What happens is, if the bicycle was destroyed when the buyer received it before the contract was void, it could mean that the buyer may not have the obligation to restore the bike itself or even its value, because the value does not exist anymore. He could use that de-enrichment claim. But for the seller, in Japan at least, there is always this presumed existence of benefit for the money. So he would always be obliged to return the money to the buyer, which seems unfair because the seller would have to return and the buyer does not have to return maybe anything. So the problem is, does or should Article 703 apply here? So that was a question that was never really solved by the court. So when the reform came, this was created into a new article. So the new civil code, the reform of the civil code, which was enacted in 2017 and was enforced just now, have now created an article on enrichment claim derived from performance. So there is this Article 121-2, which states a person who has received performance as a result of act which is void shall assume an obligation to restore the other party to that party's original position. 3 comments. One is, enrichment claim derived from a performance has its own article separate from Article 703, which is obvious. Another one is that now it is aligned with the effect of cancellation, so the obligation to restore is not limited to the extent that the benefit exists. But third, the reform did not take into consideration the entirety of unjust enrichment rules. This was simply due to the scope of the reform, which was focused more on contractual claims and the effect of claim in general. So the enrichment claims were never considered in its entirety. So here I would just briefly like to discuss about the measurement of enrichment, which is the unsolved problem of the reform. So now we do have an article stating a rule saying that there is an obligation to restore the other party to its original position, but this is a very vague term. So you don't know what this original position would entail. The principle of the measurement of enrichment, which have already been discussed by other panelists, is that when there is a transfer of tangible property, the enriched recipient is obliged to restore that which he has received. So you have to restore in kind. Only if restoration is impossible, its objective value, which is the market value, which was the principal rule in Japan. But this rule was never created as a concrete rule by the reform. They were planning to do so, but it wasn't taken after because simply due to the fact that there could be enrichment could be a service. So in that case, creating this kind of rule could just mean that there is a fallout of certain scope of enrichment. So that was the reason why they took after this vague, putting the party back into the original position. So here I would like to discuss a concrete case in Japan that might be of interest, that might cause some discussion, which might cause interest. This case, which is between X and Y, X purchased a stock of this company A, but failed to change the shareholder information from the former shareholder Y. What company A did was they split the share into 5 and issued this split of the share into Y, who was the shareholder, who was registered as a shareholder. Y, without knowing that he was not the rightful holder of this share, sold this share to a third party. So now the stock belongs to this third party. X and claimed for this enrichment claim, and the problem was, what is the value that he will get? Is it the objective value that was when Y was issued the stock? Or is it objective value of end of proceedings? Or is it the price, the sales proceed? So that was the problem at hand in court. And the Supreme Court ruled that the recipient should pay the amount equivalent to the amount of the sales proceed, applying the principles of equity. And that was the sole reason. They relied heavily on the principle of equity. What they said was recipient should not gain or lose from the fluctuation of value that occur after the sales, because the sales concretizes the benefit the recipient has gained. Thus, paying more or paying less from the sales proceed would be against equity. So here, by requiring the sales proceed to be restored, the court did not determine the calculation of enrichment by market value, because of course, not so much in this case, because this is a case of stock sold in stock market, but generally, the market value could be different from the sales proceeds. So analysis here, one convincing claim that is a claim, well, not claim as in claim, but one theory that is stated in Japanese by academics is that this claim, the court has actually admitted a claim to a substitute by way of subrogation, and that the claimant must claim for the substitute value when such value exists. So he cannot opt to claim for the objective value if this substitute exists. The reasoning is subrogated value is an extension of the original object. So when the substitute exists, one cannot claim yet that restoration of the original object is impossible. So here, I think one quick analogy might be interesting. which is an analogy with the rule permitting a claim on substitute that the debtor had acquired that the creditor may demand in case where the performance is rendered impossible. So this is a contractual claim where if you have a contract and the bicycle is broken, then you cannot perform that bicycle, the seller cannot hand the bicycle to the buyer, then the buyer may also demand for this substitute if there was something as an insurance money. So there is this new article under Civil Code 42-2 stating that when the debtor acquires a right or a profit which is by the same cause that rendered the performance of that obligation impossible, the creditor shall, within the limit of that amount of the damage suffered, demand the debtor to transfer the right or redeem the profit. So if we think about aligning contractual remedies, then I would say that substitute should be admitted for the claim of enrichment as well. But at the same time, Article 42-2 limits the loss to the damage that was suffered by the creditor. So that would mean that we should limit the enrichment claim to a loss as well. So we need to take into consideration what the loss is here. So by conclusion, I would just like to state that by reform, we have created this new article, which sort of solves the problem that have been discussed over the years. But I think this is sort of like a calm on the surface, but underneath there is this very fast current that might put us back into turmoil when determining what the just of unjust enrichment is. Thank you very much.
Thank you very much, Professor Hara, for your most interesting presentation. It appears to me that the latest development in Japan, in a way, we see some similar development in its own neighboring country, which is China. So we had a similar conversation, a similar debate in China as well. So.